And also, if you'd like to ask a question, you have two ways. You can unmute your microphone and ask a question. You can also send a chat. This is an intimate environment, so there's only clients and partners of Exportia, so feel free to ask questions. So you can unmute yourself, or you can to ask a question, or you can just send a chat. Let us know whenever you would like to ask anything. So we are going to start. I'm going to leave it to you. So it's recorded, and you unmute yourself or send a chat for a question. So off we go.
Great. So today we'll talk about the EU privacy regulations, also known as the GDPR. The D-date was last Friday, which was the 25th of May. That's when it came into force. And it now applies to a number of Australian businesses who do business in Europe. And basically, the key there, as most of you would know, is that as long as you offer products or services to a European resident, so someone who's located in Europe, then you will be caught by the GDPR, and you will have to comply if you are processing personal data. Very similarly to what you would find in Australia, personal data is similar to personal information. But I think the key part of offering products or services is also to say that even if you don't make a sale, you are still required to comply. So an online business who is targeting European customers will be caught and will need to comply. So I'll briefly tell you what I'm going to talk about today, and that's going to be basically the key concepts of the GDPR that you need to understand and become familiar with if you are indeed the subject of the GDPR. So the first thing is obviously personal data. And here it is quite obvious what we're trying to target, but I will walk you through what it means also with respect to other type of data, and also what it means to de-identify, that's the Australian terminology, to de-identify data, and when it's no longer personal data. Then I'll tell you a bit about controllers and processors, because there's this new distinction between the two categories of people who process data. This is not a distinction that you find in Australia, and it is very relevant because you will find different obligations under the GDPR depending on whether you're a controller or a processor. And a number of Australian companies will find themselves being a processor, but sometimes also a controller, and you can be both. Then we'll go through the concept of processing and also the principles and the basis for processing data, why and how you can process data. The fourth point will be consent, and that's a very important point, obtaining consent and what it means under the GDPR and how you actually obtain a valid consent. We'll briefly go through data subjects' rights, so data subjects being the individuals who are basically owning the data in Europe now, who they're taking control of the data, and they're usually consumers. Privacy by design, privacy by default, and security. Here are a few concepts to understand and distinguish, and obviously that's all part of the privacy piece, but there are new requirements under the GDPR in terms of privacy by design and privacy by default, so we'll talk about that. Then the restrictions on international data transfers, and that's when you're transferring data from one country to another, whether within the EU or outside the EU, and I'll tell you how you can do that when to comply basically with the requirements. Accountability and governance, that's more the internal piece, again required by the GDPR, but how you comply internally and you're accountable internally. Data breach notification, so when there's a breach, how you need to notify, who you need to notify, and then what happens, last point, if you don't comply. And that's the scary part, because there are heavy fines, and that's what everyone's talking about. We obviously don't have enough experience with the GDPR yet, but it's important to understand the consequences of not complying. So, personal data. So Personal data is a very important part. It is to be distinguished from other types of data. So personal data, it's about a data subject, which is basically an individual, no distinction under the GDPR.
I was going to ask you between a client, an enterprise, and, for example, a marketing manager.
Yes.
Would you treat them as personal data or not?
Yes. So if it is personal, and we'll go to that point, if it is indeed personal, then it doesn't matter who it is. So whether it's a business person, as long as it's an individual. So we're not talking about company information. So business data, for example, pricing, other things that might be confidential or intellectual property. But for example, an email address makes someone identifiable. For example, if you've got Christelle Damien at exportia.com.au, even though that's your professional email address, it still identifies you, and it's still your personal data under the GDPR. So that's an important point. No distinction between business or personal, as long as it is personal data. And what is it? It's something that identifies you, or that makes you identifiable directly or indirectly by an identifier. So a very easy, straightforward identifier is obviously your name and surname, telephone number, but sometimes it could be different. So there's been a lot of argument worldwide in the privacy world around, geolocation or IP address on the internet, cookies, etc. The GDPR, at least at this point, what we understand is that it's going to take a strict approach. If it's reasonably likely to be linked to other data that can identify you, that could be identifiable indirectly, and therefore it could be personal data. So it's quite broad in terms of what personal data actually is. A key aspect is whether you can de-identify it. So so you've got two concepts here. One is pseudonymization, which is basically taking away some parts of the identification of your data, and then anonymization, which makes it completely removed from you, and you can't identify that person anymore. A key concept there is if you are able to re-identify the person by linking it. So for example, I as a company put a number against you as an identifier, no longer your name, but internally I can link your number to you. It's not completely de-identified, so it is still personal data. So that's a key point. But if you are able to completely anonymize the data, for example, a female between an age range, because I want to use that for data analytics, for example, and it's in no way able to be re-identified, then it's no longer personal data. And then you can do a number of things. It's no longer under the GDPR. Bearing in mind that at a certain point in time, it was personal data. So within that time frame, you still need to comply. But once you've de-identified and made it completely anonymous, then you're no longer caught by the GDPR, and you can do certain things with it.
Okay. Go to the next.
Yep. So controllers and processors. So they both process personal data under the GDPR, but they are distinguished it's a very basic distinction. But basically the controller controls the purposes and the means of processing of the data. And the processor is merely the person who processes the data. They both have obligations, but basically the controller has more obligations because the controllers determine the way, the purposes and the means of processing. So, for example, if you're an IT provider and a bank tells you this is how I want my data, and you basically provide IT services, then you'd be the processor and the bank would be the controller.
And if I'm a small business, like most of the people that are in the webinar, and I'm using a marketing agency to do some targeted emailing or targeted Facebook ads, so I'm the controller and my marketing agency is the processor?
Correct. But you could then the marketing agency, depending on the type of arrangement, could also become a joint controller if they're also using that data for their own purposes, for example. So that's an interesting thing. For example, if they want to provide more services to you, and depending on the type of data, they might also become a controller. So it's important to know, and that's where the joint controller piece can arise. The types of obligations, they'll be very different, but I guess without going into the details there, what I would say is that processors have a very important obligation to assist the controller with meeting its own obligations under the GDPR. And that's a key point, because when you build a contractual relationship with the controller, what often happens, and in my experience, there's a bit of obviously negotiations and trying to push back responsibility on the processor from the controller. So the controller will try and say, well, actually, can you do this? Can you respond to requests from individuals on my behalf, because you have the obligation to assist? Now, obviously, that has a cost, and there's an implied liability issue as well. So it's a very important piece to understand, making sure that the processor understands clearly what the obligations under the legislation are, and then when negotiating the contract, just understanding how much of that additional responsibility they're happy to take, depending obviously on the commercial terms. So processing is obviously anything, it's very broad. Anything you do with personal data is considered processing. So collection, use, disposal, that's all those items are processing.
So recording the data into a database, for example.
Yes.
Yep. Or sending, emailing.
Sending email. As long as you basically do anything with the personal data, we're only talking about this one, it's processing. 7 key principles for processing. So they're the ones that basically you need to bear in mind at any point in time when you do processing. The first one, or the first category, is lawfulness, fairness, and transparency. So what you say you're doing with the personal data, you actually need to be doing that. You can't do something else. You need to be transparent. It needs to be fair. Necessary for what you're saying you're doing. So it's a pretty logical approach. Having said that, you need to bear that in mind every step of the way. Purpose limitation is the second one. So the purpose is very important. It will be in your privacy policy or privacy notice. And it needs to be exactly, again, what you say you're doing. So you can't use the personal, say you're going to use the personal data for one purpose and then use it for a different purpose. It needs to be clear, and obviously it needs to be lawful. Data minimization, you only need to use or collect the data that you need for that purpose, that lawful purpose. So the approach is, it's not what is nice to have, it's what you need to have. You can't just take whatever feels, right.
Okay.
You need to really have that strict approach. Accuracy, so it needs to be accurate, and there's a right to the right for individuals to get their data corrected. Storage limitation is another one, so you can't keep the data for too long. You need to have like a retention policy, basically, depending on the type of data.
So what does that mean, too long?
Well, there's no...
If you're a 20-year-old business or even 30-year-old, and you've got that data with you and you've been working and in contact with those people.
Sure.
So what?
It goes back to the purpose.
Okay.
So why do you collect it in the first place? Why do you use it in the first place? There's no prescription under the GDPR of what that period would be. It needs to be adequate for that specific purpose. So for example, if I'm concluding a sale and I'm collecting data as part of the sale, well, once the sale is done, I don't need that data anymore. However, if it's been made clear that there's going to be marketing initiatives afterwards, and there's a clear basis, a lawful basis, for example, consent has been obtained from that person to do that down the track, so you've got a second purpose, then you can keep it for a bit longer for that purpose. So it needs to, it's a case-by-case basis, but it needs to be reasonable. You can't just obtain that data for one sale and then just assume that you can keep it for 20 years.
Okay,
for
so
other sales.
if I'm selling a machinery or piece of machinery and I'm selling that product,
yes,
then I need to do, after sales service. So probably in my contract, I need to say that we'll be in touch for 20 years because there's a guarantee of 20 years.
And that goes back to transparency.
Okay.
And just making sure that even in your privacy policy, you say, we're keeping the information. You don't have to say how long you're keeping it for. It would be better depending on the business, there's some margin. But I guess, again, you can't also then keep it for 20 years and send marketing materials. If you keep it for that specific purpose, which is after sale service, maintenance, then it needs to be kept for that purpose only. Integrity and confidentiality or security is another one. We'll go through that. So basically keeping the information, the personal data safe, and accountability. So internally making sure that you do the right things around privacy, and we'll touch on those. So these were the 7 key principles for processing. Then we've got the 6 lawful bases for processing. So why am I entitled to process the information? Now, there's 6 of them. I'll quickly tell you which ones they are, but then I'll stop on a couple which are the most relevant ones, I guess, for most companies. First one being consent, and that's a key one. If you have obtained the consent of the data subject, then you can process, and we'll go through that. Contract is another one. So contract of sale. You've obtained the personal data. You need to deliver the machine. Yeah, that's the contract. Legal obligation, you don't have a contract, but you've got a legal obligation to report or keep that information. Vital interest, very rare if it's to protect someone's life. So I'm not sure whether anyone is in that business, but hospitals, for example, that could be one. Public task, again, it's clear basis in the law for a public task. And the last one is the second one I really want to touch on, which is legitimate interests. So basically it is, you've got a good reason. And the 2 key ones for me and for the clients that I advise are consent, which is an objective one. You go and ask consent from the person you're collecting personal data.
For the noise.
And the second one is the subjective one, which a lot of people use, which is the legitimate interest. I, as a company, consider that I've got a good reason to process data. Now, the second one is obviously, subjective, and you need to be careful when you're using it, but I'll tell you how you can use it. Well, at least, if you can't obtain consent, then
does anyone have a question?
Yes, could you go through those 6 key laws again? Because I couldn't quite hear. I got consent and contract of sale. Keep the information. I don't know I couldn't hear the 4th one. And then something public task, and I didn't hear the 6th one.
Yes. First one is consent. Second one is contract. Third one is legal obligation, so under the legislation, but not a contract. The 4th one is a vital interest, when you're trying to protect someone's life, for example. The 5th one is public task, so if you've got an official function. And the last one is the legitimate interest.
Thank you.
That's okay. And you only need one, okay? So you only need one lawful basis for processing.
Okay.
Unless, I'll say another point, unless there's what we call here in Australia sensitive information. So special type of personal data, like for example, ethnicity or sexual preferences. If you are processing that type of data, you also need to have an additional condition which is not listed here. Okay, but that's only for sensitive or special type of data.
So let's say I have a little Fitbit device where I'm recording somebody's performance when it comes to I don't know, physical performance for running or breathing and their rate. I need to anonymize that data and ask them their consent as well to record that.
Okay, so It depends whether it's personal data that you're collecting or whether it's not personal. So is it linked to that person when you collect
Yes, so they wear it, so they...
yes.
But if you collect that information and you don't know who is wearing it, so it's off, the unit is identifiable like unit A567, but you never know who's wearing it, you don't know their name, but you do know what company they work for, but you don't know their name.
It needs to be reasonable in terms of whether you can link it to the person. So if there's any reasonable basis for you to link it to that person, even if you don't have the name, for example, you might be able to get their name, or someone else might be able to get their name. It's personal data. If it's impossible to, almost impossible to do that, then it's not personal data.
Okay, so if there's no name attached to it, it's only a code.
Yeah. If you're able to link the code to the person by any means, reasonable means, it's personal data. If that code cannot be linked at all, for example, if it is off the shelf and there's no registration at all, or there's no app linked to it, then it's not personal data.
Okay.
So when you say, sorry, I missed that, but it sounded like you say when there's no app.
So for example, if I register for an app and I put my details, my name, etc., there's a way to link the data to my name and my person. So I can
see. But if the app was downloadable but with nowhere to put your personal name, then there's no way to link. There's no way to know that individual's using that system.
Yeah, if there's no way to link, then it's not personal data.
Perfect. Even if you know the company that they work for.
Well, again, that could be an indication. So, for example, I know the company, I know they're the CEO. There's only one CEO in that company. It becomes identifiable.
But if it's
but if I don't say they're the CEO, I mean, why would I need to know they're the CEO? I'm only collecting the unit number and the company name. I'm not collecting their title.
Correct. But I'm just giving you that example because, for example, even if you don't have the name, but you have, other items that moving to that individual, then it might become personal data. If you only have the business name, for example, and there's no other way to identify that person, then it's not personal data.
So if we have a database of people where with newsletters and things like that in it, I mean, obviously that's personal, as you said, there's a name and there's an email address.
Yes.
And on the other side, we have a whole bunch of Internet of Things equipment collecting data, but we're not linking the two together. So we've got a database of individual names and we've got some data with individual unique numbers. They're not linked.
Yeah, as long as there's no link whatsoever, but not even internally. That could be external. For example, if I am an external party and I manage to get hold of those two pieces of information, and with a third piece of information that's available, then you've got an issue. But it's no link.
But when you say issue, it's just that we have to protect it, right? Like it's not an issue. It's just that we comply. We have to comply.
Yeah. You've got to comply, you've got to get consent or another lawful basis for processing.
Yep. Thank you.
That's okay. So to the next one, which is consent, I think, which is quite...
just put you back on mute if that's okay for the moment, and you can unmute yourself at any time. Thank you.
So going to the next slide, consent is one of the key lawful bases for processing. So it must be freely given, specific, informed, and unambiguous. I think the point here that I want to make is if you compare it with Australia, it can't be implied, right? Okay. The GDPR is very clear. It needs to be express consent. It doesn't say express, but I think the wording is pretty clear. And one key aspect is the opt-in. So we all know that opt out and unsubscribe and you get those emails. But now you actually, if you want to get consent, it needs to be an active consent and you need people to opt in. And it's clear that a pre-ticked box, for example, when you get consent, will not cut it. So you can't.
So they really have to tick the box.
They have to tick the box. They have to tick the box for a specific consent. So if it's for a purpose, they need to understand what it means, and it needs to be unambiguous. There's been a lot of confusion around direct marketing email and what you can and cannot do. And I think the key there is that there's another piece of legislation that people need to be aware of, which is the e-privacy directive, also known as the PECR. And that's about basically emailing or phone, sort of direct marketing, fax, etc. And there are other concepts there that are very relevant. And that's also when there's some confusion around B2C and B2B.
Yes.
So I know, Christelle, we've talked about that a little bit. What do I do with my existing database?
Yes, we have a database for a long time. And what do you do? Do you re-ask everybody to opt in?
Yeah.
In an email?
So the problem there is, first of all, what I'd say there is you need to make sure you understand who's opted out. Mm-hmm. If someone has opted out before, you need to exclude these people from any emailing sort of initiative. Yeah. Honda has been fined because you can't even just to say, do you still want to be on our list? You can't do that. People have opted out. They have unsubscribed.
That's just marketing good practice as well.
Exactly. Yeah. The second piece is there's a distinction in the e-privacy or the PECR between B2C and B2B. B2B is outside the PECR, so the e-directive, but is under the GDPR.
Okay.
If you do B2C, which also includes sole traders and partnerships, but it doesn't include companies. You have to also comply with the PECR. And there is something that's very important. You either get consent, so that's the first one, or there's sort of a carve out, I'd say, if you have existing customers.
Yes.
There's a bit, it's called a soft opt-in. There's a bit of leeway about actually emailing them again for the same type of service or product.
Yeah.
So you can actually email them again. But you can't do that for businesses. So that's the funny thing about it.
Okay, because so if you're doing with a business with a company, then you can't email them.
Well, that's when you fall back under the GDPR.
Okay.
And under the GDPR, as we've seen, you've got 6 lawful bases for processing. And the 2 ones that might be relevant in that situation would be either you get their consent, so you need to actually get their consent again, or you can say, I've got a legitimate interest. So the legitimate interest is the subjective one. Obviously, if it's a sale, so the business goes online and they want to buy your services, of course, you can process their personal information. But then getting consent would probably be the safe way of processing that.
Yeah, because if I'm selling something to them, but then after that I want to market to them another product, then I need a consent from them to market that other product to them.
Correct.
Okay.
Yes. So emailing everyone, getting their consent is probably not a good idea either, unless in the past you've had good practices of making sure that they could opt out or unsubscribe. So you need to look at your previous, pattern, making sure that you had those practices in place. And if that's the case, then you might be able to email a number of them to get their consent. But the no is emailing people who have unsubscribed before. So
what about asking for verbal consent? Calling people and saying, hey, are you still working there? Can I keep you on our database to email you newsletter?
So you could do that. The point there, and that's to my last point on this slide, is to keep records, and that's required under the GDPR. So you need to make sure you keep records, and even online when you get consent. So that's something you need to prove down the track that you've actually obtained that consent, and that consent was unambiguous, specific, informed, and freely given.
Okay.
So getting
I'm going to ask a question.
Yes.
Hi, this is Cheryl from Bronx. We have a database in Europe of 600 that are in that database. They're all businesses that we may work with at some point. We have a company inside the EU in the UK, and we also have a company here in Australia. So what I was told to do was to send an email to all of them to ask them to re-opt in. And now out of those 600, we've had about 25 come back to opt back in. Because I sent it through MailChimp, there was about 80% that weren't opened. So now I'm in a quandary as to what I actually do now.
Well, to comply, you should really delete all other information. You can't process or even keep, storing is actually processing. You can't keep that information unless people have opted in.
But what if they did opt in at the time and Cheryl has some record as to there was a transaction with them, I don't know, I've sold to them or, and they gave their consent somehow at some stage.
But again, what consent? What was it for? What was the purpose?
Most of the ones in our database are ones that we've talked to people at trade shows. So it's mainly for sending marketing material out. But yeah, it's just what to do now with those ones. I understand what you're saying, but 80% from the MailChimp statistics show that they weren't opened. So can I resend something to them or am I not able to do that?
No, I wouldn't send anything else. And as I said, if you have obtained their consent, it was clear. And, that's the difficulty with the trade show is how do you keep a record that it was clear and that, what purpose was it for? Did you actually consent to marketing materials being sent? Or were they just happy to receive just one piece of marketing material? Were they happy to get info about some products, but not all of the products? So it's how you can prove that down the track. That's the big.
How do you manage the trade show? That must be a big conversation at the moment.
Yeah. So trade shows are going to be difficult. I guess it's how you.
It's not difficult. I mean, they just can't. I can't imagine how these trade shows will collect leads now.
Yeah, because trade shows, you scan people's badges with all their information on it. They've put they accepted to be scanned, or they gave you their business cards with information. So does that mean we need them to agree when we talk to them, you will receive some marketing information as well?
Correct. Another way around it, because I've got people in the event management, is to have the event organizer helping with that as well.
Yep.
So at the time of registration, they could have a list of all the exhibitors and the participants and getting that consent at that point in time. The difficulty is to make consent and making sure that consent has been validated.
Yeah, but to your point, it's not just consent, it's consent about this product or what type of, so I'm an exhibitor and the exhibitor next to me wants to use the information slightly differently. Do you see what I'm saying? So how does the organiser get consent for all exhibitors? That doesn't, it'll have to be an opt-in, it has to be opt-in for that particular company or exhibitor.
It's just
under your...
Yeah, I'm just saying the event management company that I was talking to was in a specific sort of event industry, and so it might be different to the ones you're familiar with, and with exhibitors that are very different from one another.
Yeah. So that means, for
example, we can't take records at a show. You can't take records. You've got no proof that they've opted in.
But you could have a form that they fill out and have it a consent tick in on that form. Correct.
And again, it depends on the purpose. You could also rely on the legitimate interest. If you think you can't actually obtain consent, you can rely on the legitimate interest. If you think, for example, it's a sale that you want to conclude, the marketing piece is a lot harder because it's not implied when I give you a business card that I want to receive all your marketing material.
Correct, exactly. So you still lack the fundamentals, right? Which is, if it's a trade show and it's an early lead and you don't know where that's going to go, it's not like you're midway through a sale.
Yes.
To conclude a sale, you're actually trying to get the sale going. So apart from a form that someone ticks and signs that you keep, you've got no way of collecting their data legally.
Yeah, you need a record. So if that's the form is definitely, you know, one thing you can use. That's that would be the most straightforward way of obtaining that consent at that point in time. Yes.
Thank you. That's really clear.
So one more question, just on this idea about the individual versus a company. You said a B2B is outside of the GDPR, is that right?
No, the other one.
Oh, it's outside the GDPR, is that right?
The PECR, which is the Privacy and Electronic Communications Regulations.
Okay.
So that piece of legislation that was actually going to be my last point on this slide is going to change. There is regulation coming up, and that's probably coming up at the end of the year or at the beginning of next year. So that's something to watch. But what we can think will happen will be that it will likely align with the GDPR requirements. We will probably take a stricter approach in terms of existing customers.
I see.
But
so where you've got an individual who is part of a business, they're the CEO, they're the purchasing officer, and they put in an inquiry on the website or whatever, and they use their Gmail account.
Yeah.
A lot of them do that. What do you do at that point? They're a business, but they're not a business. Or what if you've got small sole traders who are using Gmail accounts as well? How do you know, or how do you distinguish? What do you do with them?
Well, the trouble is you don't know. And the safe approach would be to comply with both.
Yeah, okay.
So, but yeah, there's that difficulty of not knowing. You know, if you've got one person, you don't know if it's a sole trader, you don't know if it's a business, depending on the email address. So the safe way is to comply with both.
So you probably need to have something on your website at the form, on the form when they ask for something. You just have something there.
To be honest, I think we are moving away from the distinction between business and a private person. With the GDPR not making that distinction. I think the e-privacy regulations will probably go towards that. They will probably keep that distinction, but the end result will not be worth, I think, the hassle trying to pull it outside of the legislation, because one way or the other you will be caught.
So can I just ask one more question? The e-privacy, how is that different? What's got to be taken into consideration with that? Is it our privacy statement on our website, or is it something different?
So the e-privacy is only about electronic communication. So for example, emails, phone is also covered. So when we talk about direct marketing, that's when the e-privacy piece comes in.
Thank you.
The GDPR is broader than that. It's any processing of personal data. E-privacy is really about communications.
Thank you.
Going to the next one, unless someone has a question on this. We'll just go through the data subjects rights. So the GDPR really empowers individuals with respect to their own data. So it's quite a different approach to what you find in Australia. So that means down the track that people will be able, I guess, to do what they want with their own data and take control. So the first one is to be informed, and that's obviously the privacy policy, telling people what you're doing with that data. Right of access and rectification, very similar to what you find in Australia in terms of access and correction. But the right to be forgotten, so the erasure piece is different to Australia. So you, as an individual, a data subject, you have the right to ask that your personal data be deleted in certain circumstances. So that's quite a new sort of approach. You have the right to ask to restrict processing to certain aspects. So again, going back to the purpose of processing. Data portability, very important one. If I want to change, I guess, operator, for example, as an individual, I can ask you to transfer or at least to give me my data in a way, in a format that I can actually use easily with another provider.
So can you give an example of that? Because what operator are we talking about? Are we talking about a CRM provider and I'm transferring data from one CRM provider to another? I do need to ask to inform.
Yeah, for example, I've got data with a phone company or an internet company. I want to change provider and I have some personal data there. That data cannot be mixed in a way that it's not portable. And if I want it to be transferred, I need to have it in a format that the other company will be able to use. So that's the data portability. We're still talking about personal data, so it's quite limited in a way. It's not any data. But there needs to be an effort on the company to make sure that it is feasible. It's not a format that's not widely used, for example.
Okay. So for example, that means if I'm using a MailChimp or a Salesforce, they have legally the obligation to give me the portability for me to recollect all my data and move it somewhere else. If
it is personal data and it's yours, you can have that request. Right of objection, and again, if I think I haven't consented to it or that you don't have a legitimate interest, then I can object to you processing my data, for example, storing it, or other things. And then the last one is profiling or automated decision making. I can ask you not to do that. So
not to profile me.
That's exactly. That's correct. So again, that's an area of interest. We'll see what the developments are, but I think when it comes to new technologies now, profiling is a very key piece.
So maybe can I jump in on Facebook ads then, because that's really what it is. This is profiling. So who's responsible? I assume I don't have the means to know and ask the content of all my 40-year-old male gardening, but like if I'm doing a Facebook ad for that population, I don't know who they are. I can't ask their consent. So I assume that Facebook is going to have the right to let us do that, and they're asking the consent in their privacy policy. Is that right?
Yeah, there's a lot of discussion around that, because Facebook, like Google and others, are quite obviously powerful in that space. And there's a debate around who's the controller and who's the processor, because that will mean different obligations and obviously different costs. But that will also mean taking control over that space, I guess, in that market. So yeah, the digital agency, the digital marketing agencies are quite unhappy with what's happening at the moment. So certain types of services offered by Facebook or Google will fall under, I guess, the controlling part. So they'll be considered controllers.
Yes.
For some of the services, but for other features, you might be considered the controller.
Okay.
And you might need to get consent, and you might need to prove that you've got a lawful basis for processing.
So what you're saying is, watch this space. This is not defined yet.
It is not defined yet.
Okay.
Obviously, you need to. I guess the first part of call is to have a look at what Facebook is saying in the terms and conditions of use when you're subscribing for one service or the other.
Yep.
Having a look, obviously, at their privacy policy. But just to understand what your responsibility is and making sure that you're in line with that. The problem is with the Facebooks and Googles, the bargaining power and the negotiation power is very limited. So, but you need to understand what you're rating for and understand what they will do with that and what your responsibility is.
All right. So we have 6. Privacy by design.
Yes, I want stay too long on this one, but basically you need to have to understand the distinction between privacy and security. And a good example that was given by one of the privacy experts at one of the presentations I attended was basically security is the vault. So it's how you keep the information safe. The privacy piece is a bit broader than that. It includes security, but do you have the right to actually use or store that data? But the security piece is very important because you need, and it's a requirement, to keep the information safe. You need to take technical and organizational measures to achieve that. And that's both for the controller and the processor. So that's very important. Privacy by design. When you design your product, your platform, for example, you need to bear in mind all these principles, the 7 principles I told you about. So transparency. You also need to bear in mind the rights of individuals, so data portability, so making sure that it is achievable when you design your product. Going to the next slide, restrictions on international data transfers. So where do you host, where do you have your servers, where do you collect the information? Very important because obviously being an Australian company doing business in Europe, you might be caught by the restrictions on international data transfers. So we can...
And I may add, for Australian companies that have their data in the UK, if I may add a complexity.
Well, the UK, just to clarify, for the GDPR, you're still within the GDPR.
Okay.
So you still need to comply. There's legislation that's been adopted in the UK that is basically adopting the same principles. So you still need to comply.
Okay.
So if the transfers occur within the EU, then you're fine. If it's outside the EU to a country with adequate level of protection, so it's basically where the EU Commission has said that country is fine because they give you an adequate level of protection. You can transfer it safely without doing anything else. The key point there is there's a list of countries that will be updated from time to time. At this point in time, New Zealand is in, so considered as an adequate level of protection country, but Australia isn't.
Is not. Okay,
so it's interesting. It's probably a timing issue.
US?
So the US is a pretty different one in terms of there's something called the Privacy Shield. So it's basically a sort of certification between the EU and the US. So it's like a bilateral sort of relationship. But another point that's interesting is you can also transfer outside the EU if you put appropriate safeguards in place. And there are a number of ways of doing that. The easiest way, I'd say, being having a contract in place and adopting what we call the standard contractual clauses. So they're basically drafted by the EU.
Next slide.
No, there's, I think, one question there. I'm not sure.
Sorry, is there a question from anybody?
Maybe not.
Yes, my question was with what you just said, that we have a website that will pick up information from the EU for our people who want to come onto our database, like join our newsletters. That server for that website is in Australia. With what you've just said, that where Australia is not on the list, what do we do? Because that information comes in on a form, but is still held in the back end of the website.
Yeah. So, are you processing data? Is there someone doing anything for you? Are you using that data for yourself and collecting and processing for yourself?
Collecting that data. So on our website, it says, would you like to opt in to receive our e-newsletters? So they fill in their name, company name and email. We add that to our database for sending mail outs. We've already put up the form with the tick so that we can be compliant. But my concern is that their details are in the back end of the website on an Australian server.
Yeah, so there's something called the standard data protection contractual clauses. That's basically a set of provisions to ensure an adequate level of protection. And that's drafted by the EU. So it's a contract basically. So you will do certain things. You will ensure that the data is protected in a certain way. You
So
can
how do we do that? How do I prove that that data is safe? Because is it our host that has the website that has to maintain that, or is it something I have to do?
Yeah, so you'd need to have a contractual relationship with your hosting company, and that's going to be, you probably have a contract already. Yep. So the first thing to do would probably be to ensure that you review that contract and ensure that you adopt the standard contractual clauses for the processing.
Sure.
So they have to guarantee that to you, basically.
Yeah. There's this set of provisions, and I'll go through the data processing agreement as well when you use third parties, which is also something you need to have in place.
Okay, thanks. It's getting more tricky.
Okay, so going to, sorry, the last point was if you do just a one-off or you have infrequent transfers concerning just only a handful of data subjects, then there's also an exception there in terms of the restrictions, and you can probably do it in certain circumstances.
So that's saying if, say, we get one or two coming in to sign up for the e-newsletter, that's acceptable?
It could be acceptable, yes.
Okay.
Next slide.
Yes.
Just mindful of the time.
Yes. So accountability and governance, and that goes back to what you need to do internally, the steps you need to take. So the big piece is having a privacy management framework, and that, it's the GDPR or any privacy legislation. It's basically that framework internally that helps you complying. And as part of that, you will need a privacy policy. It's called in Australia, privacy notice. In Europe, so there's basically the public document going to the world saying what you're doing in terms of processing. It needs to be in plain language. It needs to be easy to understand. And in Europe now with the GDPR, it needs to have certain things that are compulsory. So in terms of what information you collect, who you are, etc. So it's prescribed basically content. The data processing agreement and standard contractual clauses, that's what I just mentioned. That's when to ensure the relationship between the controller and the processor is provided for in terms of apportionment of responsibilities and liabilities, and also the adequate level of protection for consumers or for data subjects. That's the standard contractual clauses. So that's that piece that I was just mentioning before. That's a mandatory contract. So if you've got a controller and a processor, there's a bit of debate as to whose obligation it is, but ultimately, the two parties, you just need to have that contract in place. Training, you need to train your staff, making sure they understand the privacy legislation, the GDPR, so that they can do the right thing, particularly around, data breaches, sending the email to the wrong person, etc. So very basic concepts there, but making sure they understand. At the time of joining, for example, a company, that's very important, but also ongoing. Having a data breach response plan and a recovery plan. So I'll go to the data breach piece later. Appointing a data protection officer. So that's not always required, but that's an obligation for both the controller and the processor in certain instances. And that's a person that is independent, but it can be an employee, but it needs to have like an independence for that role. So making sure it's not influenced by anyone. And it's basically to monitor the privacy, making sure you comply with your obligation. And documenting, so the records are very important under the GDPR. So documenting processing, so keeping records of your processing activities. Documenting responses to data subjects requests. So if I request correction or deletion of my personal data, so making sure you keep a record of that. And also the data breaches. So if one occurs, description, when it occurred, what sort of response, what action you took, etc. So all of that needs to be documented.
Next one.
Next one. Yeah. the notifications. So data breaches could be anything really, from, you know, the hack, which never happens. Everyone think a data breach is a big hack by, you know, Russian spy. That's not always the case. In most instances, what you'll find is a human error, someone sending an email to the wrong person. So that happens all the time. Someone losing their phone, for example, on public transport. So that's a data breach if it contains personal data.
Yes.
It could be something else.
Even if it's protected, let's say on my phone is protected.
Very important piece there. So you need to, I guess, mitigate the risks. Because breaches occur, but did you mitigate that risk? Do you have encryption, for example? Is one of them. But for example, I send the wrong email or the right email to the wrong person. Am I able to recall the email? If I'm not able to do that, have I sent an email to the person saying, sorry, I made a mistake. Can you please delete? You get confirmation that it's been deleted. Now you've taken a number of steps to actually mitigate the breach and contain it. So they're very relevant, because then when determining whether you need to notify the regulator, that's going to be very important. One thing to bear in mind that's quite important, a difference between Australia and the EU, notification of a data breach to the regulator in the EU will need to occur within 72 hours from becoming aware of the breach. That's a very short.
The EU server is going to explode.
Yeah, well, it's to the regulator. So, but yes, I think they have a lot on their plate at the moment with notifications. The other piece is whether you need to notify the data subject that have been affected by it. In Australia, you have that notification to both the Privacy Commissioner and the individuals affected. Under the GDPR, it will be only under certain circumstances. So very limited.
Next.
Yes.
Sorry, I have a question just on that. So let's come back to the losing of the phone and notifying the data subjects. Is that losing the phone in Europe, or is it European personal data losing the phone anywhere else in the world?
So losing it anywhere else in the world if you have personal data of a European resident.
Yeah, okay. And if those phones are not owned by the company but are used for work, what's the process there? So for example, salespeople bring their phone to the job and have a whole bunch of personal, network contacts, etc. in their phone. They use the phone for your business.
Yeah.
They're either European or not European, but it doesn't matter. So they do have European contacts in their phone, and then they lose the phone. There's a breach and you need to notify, right?
Yeah, so it will depend what personal data was in the phone, whether there was some that was collected by you.
It's typical, right? Like you've got their name, you've got their title. I mean, as a sales rep, you've got their company that they work for. You have an email address, you have a telephone number, pretty standard stuff.
Yeah. What I'd say is you don't have to notify all the affected individuals in all circumstances. It's only when there's a high risk to the rights and freedoms of those individuals. So it's pretty limited. It would, if it puts them in danger, for example, it's pretty obvious there's a high risk. If it's just basic information, name and number, no location, for example, it's not a witness in a serious criminal case who could be endangered, then, you're in a different circumstance. So the point is, the regulator will likely be notified, but whether you will need to notify all the affected individuals, it will be just in certain circumstances where there's a high risk.
But if you have on apps, for example, you have apps on your phone and you password to get to them, then you're safe, right? Because you have your CRM, and it's typical as well. We have our emails, email apps, and our CRM apps on our phone. So, but do I need then maybe to save a password to access to the
Yeah, so encryption and making sure that the information is safe and that it's unlikely that someone will be able to access it. That will be relevant in the consideration as to whether.
But just so I understand, because this will be happening every day, right? Like, you know, people working, losing their phones with information, even not even getting into the complexity of apps or anything, just, you know, you Google whatever. I just want to understand, and you know, taking the life-threatening thing aside, again, not really sure what circumstances, the average salesperson, whose responsibility is it? Is it the company or is it the individual who loses the phone?
Okay, so it will. You need to have a contractual relationship with the salesperson. Ultimately, someone will need to notify who it is and who's responsible for it. It will depend on how you've apportioned that liability between you. If it is considered your employee, you've got the data, then it's probably you. If it is someone who has more responsibilities, not just a salesperson, who's actually processing information as well.
No, I'm sorry, you've lost me. So we're just talking about a really vanilla flavoured story where we've got salespeople with their phones. They own the phones. We don't access their phones as a company. It's their phone, but they're using, obviously, a proportion of those names are being used for our business, but they're our salespeople. So
well, you have to notify then. If they're your salespeople, personal information processed by you.
No, it's not personal information. So I'm not saying it's not, we don't access their phone. They access their phone. Or are you saying because they're a representative of the company, they're accessing a personal, I see.
Yes.
Okay.
So they're your products, right? They're your sales.
I see.
The information is processed by you, basically, even if they do it for you or your employees do it for you, whether they're your employees or just your contractors, it's still you processing information.
But we're not processing all of their phone. We're only processing it where it's relevant to our product. So those other individuals in the phone, whether they be private or from a previous job or whatever, how does that get managed?
Yeah, no, it's not your responsibility.
Okay, so I'm not even saying from a losing the phone point of view, but that's not a database we own, is it?
Yeah, no, it's not personal data that you've got anything to do with. So
right, I see.
So I guess just the last piece, just bearing in mind the heavy fines under the GDPR. So there are different, I guess, types of notice with different fines applying, but I guess what's been in the paper is the highest one, which is basically the greater 4% or 20 million euro, 4% of the worldwide annual revenue. So that's of the prior financial year, or 20 million euros. So that's sorry? Okay, so it will need to be, there will need to be a number of factors to be considered, whether, you know, the fine will be applied, it will need to be proportionate also. So there's a discretion there. There's also right to complaint and obtain a remedy if you're not happy with what's happening. So as an individual, you can complain, and right to damages. So in addition to the fines, if you've suffered prejudice, yeah, you can you have the right to claim damages as well. So very heavy fines to bear in mind, but again, we'll see how that applies in practice in the coming months.
Sorry, just a question here from Colex. Is the GDPR, the authority, are they going to look to pursue companies for compliance, or are they really responding to individuals' complaints?
They also have a right to investigate. So yeah, they could do something themselves. I guess they'll be very busy addressing a number of issues. So, you know, whether they'll go after the small players, probably not, but who knows? They do have the power to do it, to investigate.
So are Facebook and Google scared, or?
Sorry, Andrew?
Are Facebook and Google scared? Because their business model is...
Oh yeah, yeah. I think they are, because they're the ones who would suffer a lot if it was the 4% of their annual revenue. Yeah, so I think that they've got a lot to be worried about.
The little old Alex probably doesn't have a lot to be worried about if we're doing a decent, honourable thing.
How do you manage something like Facebook.com? How does that work? Because they actually house your personal data. They're obviously processors in that, I guess. Processors, would they be? How are they managing that? Is it just that they put in lots of protection and privacy and whatever, and you're the portal, so you're the one who has to be responsible for it?
Yeah, there's a lot of controversy there. There's a lot of arguments. Some lobbyists have been complaining already. Also, consumers have been complaining that they're forced to consent to use the services, which shouldn't be the case. You know, you can't say, it's either you give your consent or you can't use the services. That's not a valid consent. So a lot of arguments. I think, you know, we'll need to have a look at what happens next. I think Facebook and Google will probably be in the papers coming weeks.
3 days, $365.50. I'm to go ahead with that one.
Yeah.
And MailChimp too must be deleting a whole bunch of databases, I'm assuming, or unless they already were.
Yeah, they're working a lot on that.
Yeah.
And I'm sure everyone has received 50 odd emails on the weekend with updated privacy policies and consent, etc.
Is that something you recommend to do? All the people
No, don't email everyone updating your privacy policy. Again, that could be construed as actually not complying.
Okay.
So it is not the approach I would take. But I think moving forward, I mean, the privacy piece is a moving one. It's how you understand your obligations, and you know, the first thing I would do would be to have a look at the privacy policy. Definitely update it, your privacy policy, to make sure it complies with the GDPR, and then looking at your practices internally.
Yeah. So I'm just bearing in mind the time. So if anyone has one last question.
I guess it's not a good idea to buy lists of target clients anymore. There's no way.
Buy databases or buy lists of contacts.
Okay, so that one, you need to have a look at the PECR and the e-privacy, and that will likely change. But yeah, you just need to be really careful about that and how you use it. Yeah. There are a number of lists as well in the EU of people who have said they don't want to receive calls or emails, and you need to have a look at those as well.
Yes. So let's say I buy it from a marketing agency which has a list and selling lists, in the business of selling lists, because you get a few of those around. So they need to sell you a list that complies with all those.
Yeah, but again, depending on what you know you're intending to do with that list,
you can't even ask them that.
What are you going to do? Yeah. So
Okay. Yes, Andrew.
You're
right.
limited.
I have one more question. We recently had some business development work done for Poland, and our database was updated as a result of that, or we haven't added it to our database yet. Now, what do I do? For example, I can't just put them into our database. Can I contact them to say, we would like to add you to our database? Would you like to consent? That type of thing, or not? Because we're already doing like business development work with them to find out what their interest is to work with our company.
And so their businesses, right?
Yeah, their businesses. And so they can be contacted. They can say, no, not interested, or they can say, email me later. So you know each company what their response is.
Yeah. So if they ask you for something, you can use that to respond depending on what they wanted to do in the first place. So you don't have to delete that information.
So at this stage, they've been sent information that they said, yes, okay, we're interested, please send us this information. But my question is, I can't really add them to our database for our mail outs, our newsletters, unless I get consent.
So what did they agree to, sorry?
They agreed to, yes, please send us some brochures, we're interested, or we might be interested in having a visit from your company. We didn't actually ask the question, can we sign you up to our database?
Yeah.
Because
So
this is just prior to the GDPR.
Sure. What I would do there is when you send them, or what a lot of people have been doing, when you send them information that they have requested, just asking them if they want to opt into your newsletter and be on that database at the same time.
Sorry, say that again. Ask them
if they want to opt in to get marketing materials.
Thank you.
At that point in time.
Yep, okay.
All right. I think we'll wrap up because it's 15 past. I've left here Christelle's contact details, so feel free to touch base with her. She'll be happy to go through your own specific questions and help you out.
Yeah, sure.
The link to the recording will also be sent out to you guys. So I hope it's been helpful, and I wish you a very good continuation on your day.
Thank you very much.
Thank
Wonderful,
you.
good information. Thank you.
Thank you. Bye-bye. Thanks, everyone.
So can we take this as
Thank you.
for us to contact you?
Yes, I'll send you the contacts of Christelle as well.
Sorry, I'm being a little cheeky, but you've given us a business card.
You give your consent to be contacted, Christelle?
I'm not sure. I want to see your privacy policy first.
On the website. All updated.
Okay, see you everyone. Thank you.
Thank you.